Ready, start. The exclusion of a dispute from arbitration may be expressed or implied, depending again upon the nature of the dispute, and a party to a dispute cannot be compelled to resort to arbitration merely for the reason that it has been provided in the contract. Full stop. The arbitrability of a dispute has to be examined when one of the parties seeks redressal under a welfare legislation, in spite of being a signatory to an arbitration agreement. Full stop. Double inverted comma, the Consumer Protection Act, double inverted comma close, is definitely a piece of welfare legislation with the primary purpose of protecting the interest of a consumer. Full stop. Consumer disputes are assigned by the legislature to public fora, as a measure of public policy. Full stop. Therefore, by necessary implication, such disputes will fall in the category of non-arbitrable disputes, and these disputes should be kept away from a private fora such as double inverted comma arbitration, double inverted comma close, unless both the parties willingly opt for arbitration over the remedy before public fora. Full stop. The question, however, is of election, or of choice, and not of which party had approached the court first. Full stop. More importantly, it would be the nature of the dispute, which would determine the forum for its redressal. Full stop. The law gives this choice to the consumer to either avail a remedy under the Consumer Protection Act, by filing a complaint before the judicial authority, or go for arbitration. Full stop. This option is not available to the builder, as they are not double inverted comma consumers, double inverted comma close, under the 2019 Act. Full stop. It is the respondent here who has to make a double inverted comma choice, double inverted comma close, between submitting before the private fora, that is the arbitration tribunal, or to make a complaint before the consumer forum, which is a public fora. Full stop. She has chosen to go to the latter. Full stop. Her reply before the Telangana High Court on the Section 11 application of the builder is not her submission to the arbitration process. Full stop. In a reply, she informs the High Court of the complaint made by her as a consumer before the district consumer forum, which is a double inverted comma judicial authority, double inverted comma close, and hence Section 8 of the Arbitration Act, 1996 would come into play, and not an application under Section 11 of the Arbitration Act, 1996. Full stop. It was held that the 1986 Act was enacted to provide better protection of the interest of consumers and for providing a redressal mechanism, which is cheaper, easier, expeditious and effective. Full stop. For this purpose, various quasi-judicial forums were set up at district, state and national level with a wider range of powers vested in these judicial authorities. Full stop. These judicial authorities were vested with the powers to give relief of a specific nature and to award compensation to the consumer wherever it was felt necessary to impose penalty for non-compliance of their orders, and the judicial authorities were vested with such powers. Full stop. Now compare this with the power of the arbitrator. Full stop. An arbitrator does not have the power to impose a penalty. Full stop. This is also one of the essential differences between the two forums. Full stop. It was finally held that the provisions given under the 1986 Act were in addition to, and not in derogation to, any other provisions or any other law for the time being in force. Full stop. This court, in a series of decisions, while considering both the provisions in the Consumer Protection Act, 1986 and the Arbitration Act, 1996, has held that the Consumer Protection Act, being a special and beneficial legislation, the remedies provided therein are special remedies, and a consumer cannot be deprived of them should he choose to avail such a remedy, in spite of an arbitration agreement between the parties. Full stop. It is a remedy provided to the consumer where the consumer finds a defect in either goods or services provided to him and therefore seeks a redressal of his grievances before the consumer forum provided to him by the legislature. Full stop. This court ultimately held that the main purpose of bringing an amendment inter alia in sections 8 and 11 of the Arbitration Act, 1996 was to minimize the scope of judicial authority, which was to refuse a reference to arbitration only on the ground when it prima facie finds that there was no valid arbitration agreement. Full stop. The legislative intent for the amendment was confined to limiting judicial intervention. Full stop.